Lady, my lords, I was on topic 3, which was an overview of the Court of Appeal's reasons in 212 and 213, and I had identified the first of the reasons given in 212. Conscious that the court would have read these two short paragraphs a few times, but the second point, obviously, that the Court of Appeal rely upon appears at the end of 212, which is that any retrial would have to be, as it were, against Mr. Shaw, against the bank in respect of Mr. Shaw, and that would be a retrial, but a reconstitution, a different case being tried for a second time, and that's not the same as a retrial. So that's the second reason the Court of Appeal gave in 212. And then in 213, and the court would have read it, again, with commendable brevity. There are 2 points, I suppose, in 213. There's the first one, which is that in the Court of Appeal's assessment, the appellants had their chance. They'd thrown everything they could against Mr. Shaw. Some of it had stuck, some of it hadn't. So, in a sense, that's the first point they make. And the second point they're making is that on the merits, this wasn't a borderline case or a case which depended upon the clash of unresolved factual material, but was without foundation, if you want to use the words of the cost judgment, or unsustainable, which is the language of 213 itself. It means the same thing. Now, the appellant's arguments in this court are, with respect, an attempt to thrash around in the undergrowth and the weeds or some of the weeds of this case, which we say is not appropriate in the absence of a properly particularised grounds of appeal in relation to the first 209 paragraphs. But that point notwithstanding, may I now go into the weeds a little to deal with my fourth and my fifth topic.
Can I just see if I've got this right in my mind? So really, in 212, the court is saying that even if there is a sustainable case, it's not the case that was pleaded, and so it wouldn't be a trial of the proceeding on the same basis as the original trial. And then in 213, they're saying we don't think there's a sustainable case in any event because the documents themselves don't reasonably yield an inference of dishonesty, and which therefore leaves you with having to obtain evidence by cross-examination of Mr. Shaw from which it could be inferred. That's been attempted, but it didn't succeed.
Yes, or perhaps more completely, it could be said, some of it stuck with the judge for the wrong reasons, so one excludes that. But your Lordship's right. Yeah. They did not elicit oral evidence, which then led to a finding of fact sufficient for there to be dishonesty. This case is, to state the obvious, dishonesty or nothing. It's not a case about the negligence of a bank. Mr. Shaw's investigation, if judged by the standards of a reasonable investigator, will no doubt be said to be deficient, as he himself acknowledged. But the question is dishonesty or nothing. So that's right. They did not elicit evidence and get findings of fact on that evidence, showing dishonesty. So I'm cutting a little ahead of myself. On segregation, that's all a bit unclear, as the Court of Appeal say, as to precisely what was being discussed. But one thing it is clear from that material, said the Court of Appeal, was that it's not about dishonesty. Those references are not about theft or misappropriation. Query precisely what was their origin way back 12 years ago. Something must have prompted those lines, those little paragraphs in the report. But dishonesty is what it's about, and that's the only candidate in town, and that was insufficient. Both as against Mr. Shaw, I think your Lordship's asking me about Mr. Shaw particularly here, but if I can just widen the debate slightly. Of course, the non-segregation case was put against everybody who had written those words or read them or commented back on them, namely the other Gibraltar officials and the officials in Jersey in the credit department.
But in the cross-appeal, where the same documents presumably were being looked at, and the Court of Appeal was being invited to take inferences from them, by that stage, for tactical reasons, everything was focused on Mr. Shaw, because they were accepting the acquittal of the other side.
Certainly, by the stage of the Court of Appeal.
Yes, in the cross-appeal.
And that's one of the problems with the cross-appeal, because it was focusing on the author of those documents rather than some of the other co-authors and the recipients.
Yeah.
That was part of the problem. But that was the tactical call they took.
Yeah.
As you will know, in the Court of Appeal of England and Wales, when a judge does not make all the findings of fact which a party requires, the Court of Appeal encourages parties at the end of the trial to stand up and say to the judge, but we don't find any findings on the following points. And the judge then has the option of making those findings before the parties are put to the expense of an appeal.
Yes.
Is this the sort of situation in which, given the matters, the documents in paragraph 31 of the particulars of claim, the appellants could have got up and said to the judge, you haven't made any specific findings on these matters?
Well, they could have and should have. There was, if I recall, the usual brief exchange of corrections.
Yes.
From, I think, both parties. And there were a few errors of detail in the draft judgment which the parties picked up, but they all fell short of the sort of request that your Ladyship has in mind, which is to say that these are important points. You haven't respectfully decided them. Perhaps you want to think about whether you want to decide them, and none of that was done. But the next opportunity for that sort of debate was in the Court of Appeal, obviously not in the way of asking for further findings from the judge, but in the Court of Appeal you have an opportunity, do you not, to say, by way of respondent's notice, these acquittals are unsafe or unsatisfactory, they ought to be referred back to a judge. It could be the judge or it could be a different judge, but that opportunity wasn't taken either. My Lady, my Lords, topic 4 I've called investigation, and topic 5, which is the last one, I called non-segregation, and we're now going into the weeds a little. But I'll try and keep the points in my submission suitable for what this is, which is a final appellate court looking at errors of law, errors of principle, rather than the weeds of the evidence. The investigation, rather a grand term, but we know what we're talking about. The judge found that as a result of the investigation at the end of August 2005, I think Lord Reid asked the question when it was, roughly at the end of August 2005, he found that Mr. Shaw had discovered that the client was stealing money and buried it. That finding was vigorously supported by the appellants in the Court of Appeal. It's common ground that that finding was completely unsafe and indeed very unfair, but it's important to record that the reasons why it was unfair and unfounded extended beyond the Bautista lie and the Baker-Tilly file note. There seems to be a suggestion in this court that, well, really, once those errors had been made, one had to put a line through the judgment. There was a sustained attempt in the Court of Appeal by these appellants to uphold the separate and independent findings of Mr. Shaw discovering the fraud. Now, the substance of the Court of Appeal's decision on the investigation, which is loosely what I'm referring to, the substance of that decision was not just to set aside the judge's route, but in substance it was to reverse and state the contrary, which was that there was no basis, not just the judge had got it wrong, but there was no basis, in fact, for a finding that that fraud was discovered and buried. And there's no appeal from that conclusion. So, just approaching the question about retrial of the investigation strand, which is what I'm focusing on now, there's an immediate problem, which is when they're asking this board for permission to have another go at this, what do they mean by that? What are they going to have another go at? Are they seeking to run the case that the judge found to be made out that he discovered and buried the fraud in 2005? Is that, I ask rhetorically, is that the case they want to have rerun? Because if that is their case, and it appears to be their case, the Court of Appeal have found that that has no basis. And that decision is not appealed.
Could you just give me the paragraph number for the holding that you're referring to in the Court of Appeal's judgment?
I think it might be I'm not quite sure what relationship means. 115? The court, maybe an answer to a different question.
No, the 2005 investigation did not sustain the...
No, I've given you... 115 is a different point which I've just made, which is that the case that they ran wasn't pleaded and failed, so how could you have a retrial of something which isn't even on the pleadings? That's 115. Your Lordship's question is about...
the point you've just made to us, that the Court of Appeal held there was no basis for any finding in relation to what you said was a discovery of stealing and burial. Yes,
I'm grateful. Well, that's quite a difficult question to answer by reference to a particular paragraph, because it's a whole host. It starts at 158, and I'm afraid, I think the answer to your Lordship's question is, I'm afraid, 158 all the way through to 194. Because the Court of Appeal, after dealing with the Bautista lie and the Baker Tilly problem, they then look at the investigation in detail and rather granularly. And they're doing two things there, as I say. One, they're criticising the judge, but also making their own findings, not of primary fact, but evaluative findings on the materials. There was no basis for saying that he had discovered a fraud.
Am I right in thinking that really what the appellants are left with is, in terms of their pleaded case, is a case that really, a case against Mr. Shaw that depends on really quite about half a dozen documents, which Mr. Moverley Smith took us to this morning. Because the particulars on which it's said that there was knowledge of a fraud begin by referring to the documents either prepared by Mr. Shaw or, well, they're almost all, in fact, prepared by Mr. Shaw. His analysis of transfers into the office account that we looked at,
yes.
The letters or emails or reports that he submitted to his superiors about what was going on with the Marash as clients of the bank, which they're all listed on E161. And once one gets beyond that, all the other material relied upon either doesn't concern Mr. Shaw at all, because it's messages to people like Mr. Cartwright and Mr. Hewage and so on, Mr. Ramage, or it's to do with other accounts, particularly the US dollar account, the Canadian account, and the euro account, which, as far as we've seen anyway in the judgments and the transcript, weren't the subject of material evidence implicating Mr. Shaw. So, I mean, correct me if I'm wrong, but it rather looks to me as though really the case is what can be inferred from the something like 4 or 5 documents between 2005 and 2007, and the oral evidence that Mr. Shaw gave.
Well, my Lord, I respectfully agree. Can I just add some observations?
Yeah, cool.
I distinguish two things, the investigation and the non-segregation case. Now, on the investigation, the document your Lordship has in mind is the one-pager,
Yeah.
the spreadsheet, or whatever you want to call it. I think it was a spreadsheet. And the other documents that you will find pleaded in, I think your Lordship was looking at paragraph 31 of the particulars, those are dealing with the non-segregation question, which is different.
Yes, there are either credit applications yes, one's an excess referral report and the other's are credit applications.
So perhaps I can give a slightly more precise answer, actually, which is on the investigation. And the reason I draw, the reason I draw the distinction between the investigation and the non-segregation is in part for some clarity, but also because the investigation was the subject of the appeal, because the judge potted Mr. Shaw on the investigation, and non-segregation was the cross-appeal. That's part of the reason I do it. On the investigation side of it, I said there was one document, I think there are two, aren't there? There's the excess referral report of the 26th of August, which refers to the investigation, and then secondly there's that one-pager spreadsheet. And then as far as non-segregation is concerned, there are a collection of essentially credit applications and credit responses. Mm-hmm. They're called sanction sheets when they come back. And the Court of Appeal looked at all those documents. They looked at them in their conceptual order, as it were, the investigation as being an appeal point and the segregation documents being a cross-appeal point. But they looked at all those documents for their objective sense and meaning, together with their context and the inferences to be drawn therefrom and the overall probabilities. Plus, can I add in a further collection of documents, what I might call the motive documents, which are the sort of collateral documents around the edges showing how Mr. Shaw was reporting everything up. I was even saying we should get these customers to re-bank. This is a very polite way of showing them the door. You serve formal demand and they go elsewhere. All of that, they considered all of that as well and formed a view, an evaluative view, on the merits or otherwise of a dishonesty claim. And we say that that is safe from challenge unless some error of principle rooted in a wrongful exercise of a discretion can be identified. And what I was going to say under topic 4 and 5 was some submissions about the weeds, getting into the weeds of the evidence. And I do so with some hesitation, but perhaps I'll say a few points on that. But I wouldn't want it to obscure the big point, which my Lord Reed has elicited from me. There is a big picture answer to this appeal on the basis of criticisms now of some of the conclusions on those documents, contemporaneous documents.
There is a risk, isn't there? You could look at documents individually and not look at them cumulatively.
Yes.
And there's a danger of compartmentalisation,
Yes.
particularly in this sort of case.
Yes.
You've got to put them all together. Is there a place where the Court of Appeal says, looking at all the documents together, we find there's no foundation in a claim for dishonest assistance against the bank based on Mr. Shaw's participation?
Well, I can see Mr. Medcroft is already searching for a singular paragraph, but that is the conclusion of those two sections in the Court of Appeal judgment, where they go through all the material. And there is if your ladyship is focusing, as I think you might be, on the danger of a sort of divorce between segregation and that's not an error the Court of Appeal made. On a number of occasions, the Court of Appeal referred to the two topics together, pointing out that they are different. Non-segregation is not the same as theft, and they make the point that it wasn't the concerns about non-segregation that led to the investigation. So they did stand back and look at the material as a chronological flow to see whether or not any dishonesty could be inferred. And they did not make their decision on a retrial on the basis that they liked Mr. Shaw or they thought he was a very credible chap. because they couldn't, obviously, because they hadn't seen him. They don't make that error. They are looking at the materials and the inferences to be drawn from them, and the pleaded case which is based on nothing more than documents and the inferences drawn from. They of course observe that Mr. Shaw didn't ship any water. Of course, if he had done and made admissions that he had seen things which showed fraud, that would be relevant. But given that there was nothing in the record that helped the appellants, it came down essentially to the documents, the inherent probabilities, the overall probabilities. And in relation to the investigation, though I could make the same point in relation to non-segregation, and no doubt I will in due course, the Court of Appeal, we say, was well placed to make that assessment. It's not appealed. It's not a case which turns on a clash of evidence, or, as I say, the credibility in a primary fact sense, which a trial judge alone could only take a view on. I go so far as to say, I think I can say this, that in light of dismissing the judge's findings, it would have been perverse of the Court of Appeal to say, yes, this should be retried. The Court of Appeal looked at the judge's findings, said they were thoroughly unsound, took the view that there was no foundation whatsoever. It would have been very odd to have then said, but I think somebody else should have a look at it. And they, of course, reached the different conclusion. They've had their chance, and I can see no proper basis, 2 and 3, for a retrial. 6 points on the investigation at a canter, if I may. And it may help my lady in particular give a summary of the key points in the Court of Appeal's long section. 6 points on the investigation. It's from 158 onwards. The first point is the Court of Appeal noted that there was no evidence that Mr. Shaw looked at the Sterling client account. That's not a finding that Mr. Shaw is a credible chap, and I accept his evidence. There was no evidence that Mr. Shaw looked at the Sterling client account, and Mr. Mobley Smith acknowledged that there was no evidence, and that's the Court of Appeal judgment 166 and 171. Simply no evidence that he went beyond looking at the office account. Secondly, as the Court of Appeal pointed out, there was no evidence that Mr. Shaw had looked at any of the other client accounts. That's also 171 of the Court of Appeal judgment. Thirdly, so you are faced with one document, which is the one-page spreadsheet. Perhaps we could have a look at that. It's in bundle 5, if one is using the hard copy. And I think it's E1789. So this is it on the investigation in terms of contemporaneous documents. 1789 electronically. So this is the document that is supposed to have told Mr. Shaw that the clients are stealing money. First point to make about this is that there is no evidence, there was no evidence at the trial that any of these transactions were fraudulent or were thefts. Proposition at trial was that Mr. Shaw should have spotted theft from these transactions in circumstances where there's no evidence that any of these were thefts. Can I just put that into context? Mr. Magner lost money as a result of theft. By Mr. Magner, I mean Mr. Magner and his trusts. But that money was stolen from him about 18 months later. The Magner money left in early 2007 through to about early 2008. That money, there was evidence that Mr. Magner had stolen from him. But there's no evidence, and there was no evidence, that any of this involved stolen money. Second point, again, I apologise for going to the weeds a little bit, the only point that was then taken on this document was bunching. bunching of round sums. That was the appellant's case at trial. Sorry, I made that point very badly. The only point was the round sums on this page. The round sums were signs that Mr. Shaw knew that money had been stolen. The bunching point was the judge's theory when he wrote his judgment. The bunching of round sums is what he had in mind. The court may struggle unless I tell you where the bunching is and what the round sums are. The round sums are relatively easy. It's the 1, 2, 3, 7th, 8th and 9th entries, the 20,000, the 10,000, the 20,000. Those are round sums said by the judge to be bunching, and then if one goes 2/3 of the way down, there's 10th of August and 17th of August, there's a 30,000 and a 20,000 together. Those are the round sums and bunching. So that's what this case came down to, that Mr. Shaw should have realised the round sums were indicative of fraud. And the appellants, even in the case before your lordships and your ladyship, want a retrial to make good the round sum point and the bunching point, which died a death in the Court of Appeal, because there was no evidence to support the case that these were indicia of fraud. The experts agreed that round sums were irrelevant, and the bunching point was never put, was not pleaded, and it was the judge's own creature. The submission, and it's their written case, paragraph 79, is quite revealing in our submission as to what's going on this appeal. Paragraph 79 of their written case is where they're asking for a retrial to deal with, amongst other things, this point. The point they make is at the end, assuming that is right. Paragraph 79 of their written case, which is E3475. It might be 373. E3473, paragraph 79 of their written case. So the point here is that it acknowledges that there was a gap in the evidence. Well, that's I think what they mean by that is there was no evidence, and they would like to fill it on a retrial. And that is a little example. It's only an example of many, but that's a little example of what the problem is with the appellant's appeal. That's not a retrial. So that was my third big point on the investigation, which depends on that document which we looked at. The fourth point is that, and I'm trying to extract the essence of the Court of Appeal's detailed reasoning. The fourth point is that the Court of Appeal made clear that the idea that Mr. Shaw had discovered fraud and buried it was simply unsustainable by reference to the other contemporaneous documents, which I loosely call the motive documents. All the documentary evidence, there's not a single exception, sent to his colleagues across the bank and up the bank, was to the effect and supported the proposition that Mr. Shaw challenged them. He was difficult and tough with them. He was unpopular. There was a meeting on the 13th of September, which you may have picked up in the evidence. There was some reference made afterwards to the fact that if Mr. Cartwright hadn't been there, Mr. Shaw might have left that meeting through the window, the defenestration meeting. It was an angry meeting. 13th of September, that's 2 weeks after he discovered the fraud, on the judge's view at the end of August. Challenged the customers, was tough with them, elevated concerns with the bank, discussed removing banking facilities if they weren't more cooperative. And the idea, and this is set out a great deal in the Court of Appeal, The idea that Mr. Shaw would have then buried the huge news that not only are they chaotic and mucking us about and not promptly dealing with queries, but they're stealing client money. The idea that that would have caused him to bury it in circumstances where he had raised every query going is just ridiculous, and that's what the Court of Appeal said in more polite terms. And I think, as Lord Briggs, my Lord, said this morning, the appellants would have to challenge that conclusion, amongst many others, I should add, in the stage of reasoning. It's a particularly difficult point for them to challenge in order for them to show that there's an issue there, a loose end which deserves a retrial. The fifth point is the personal motive of Mr. Shaw. That was non-existent, and the Court of Appeal deals with that again at some length. Paragraph 177 onwards, there's no suggestion, no material which can sensibly be relied upon for showing why Mr. Shaw would have behaved in that way. And the sixth point is a point of detail, but it's, I raise it because I think it was made by Mr. Mobley-Smith again this morning, which is that the appellants repeatedly state in their case in one form or another that Mr. Shaw suspected that they were stealing money and therefore investigated. Whereas in fact, as the Court of Appeal point out, it's paragraph 180 of the Court of Appeal judgment, and that is probably worth a look at, 180 of the Court of Appeal. Mr. Shaw did not suspect they were stealing money. His investigation was directed at satisfying himself that there was no cross-firing or misuse of funds. He wasn't investigating actual or suspected misuse. And the Court of Appeal at paragraph 180, and if I can give you two other references on this point, 174 and 175, the Court of Appeal tested that evidence against the documents, and in particular the documents that went to the credit team in Jersey, because of course Mr. Shaw had discussed with the credit team in Jersey his investigation and his concerns. That's what the document shows. And the credit evidence was similarly that Mr. Shaw wasn't on inquiry of a fraud or suspected fraud or thought there was fraud. He was simply doing what is called KYC, getting to know the account, getting to know the customer, and satisfying himself that it all seemed fine. So that's 174, 175 and 180 in particular of the Court of Appeal. So that's a canter through 6 points of many in the Court of Appeal's reasoning as to why the investigation and the materials didn't justify a finding of fraud, either by the judge or when looked at more generally. So that's topic 4, the investigation. No basis for thinking there's anything there that could be retried or even tried again on a different basis. Topic 5 is non-segregation. This is my last topic, and we deal with this in our written closing from paragraph 64 onwards quite shortly. But let me say a bit more about it. The non-segregation case, or the non-segregation strand of the case, was twofold. One was that the bank knew that there were occasions of non-segregation. That's obviously true, that's what the documents say. And secondly, this is the important point, that those references were synonymous with theft. And the case was pleaded, as my Lord Reid has pointed out, pleaded and advanced entirely on the basis of those few documents which refer to the lack of segregation and the identity of the individuals said to know about the theft were simply those who had authored or received the documents. And it was a simple case that those references to non-segregation were in truth references to theft. In other words, non-segregation was a synonym for dishonesty. The word synonym comes from paragraph 202 of the Court of Appeal judgment. That's how the way the Court of Appeal put it. It was synonymous, just another way of saying theft. Or, as it was put at trial, using a bit of Latin, which I think comes from the pleading, there was ipso facto theft. Non-segregation ipso facto was said to be theft. And as one can see from paragraph 202 of the Court of Appeal's judgment, that's how the case was put at trial. Court of Appeal say at the beginning of 202, Mr. Mobley Smith starts in his cross-examination of Mr. Shaw. I interrupt to say, cross-examination, in fact, of all the witnesses, but including Mr. Shaw, was that non-segregation was a synonym for instances in which the firm dishonestly appropriated money, stole money. And that's the case that was put. It's quite a simple case. Every time you see non-segregation or a lack of segregation, what they actually mean, all the witnesses, all the officials, they mean there's theft going on. Now, that wasn't accepted by the judge. That wasn't accepted by the judge at all. And I emphasize at all because this allegation was put not just against Mr. Shaw, but against, as I've mentioned, the others who dealt with this topic. And we know that the judge acquitted the other 6 witnesses, including the credit personnel who dealt with the non-segregation issue when they read Mr. Shaw's reports and wrote back their comments. He did not consider, the judge did not consider that any of those witnesses, including Mr. Shaw, but any of those witnesses understood the references to non-segregation as theft. And the acquittal stretched across all the relationship managers, both before and after Mr. Shaw, before is Mrs. Lester, after is Mr. Ramaj, as well as all the superiors in the bank in Gibraltar and the credit team in Jersey. Now, as the Court of Appeal pointed out, and the 3 references to look at in the Court of Appeal judgment on this point are 72, 75 and 196. As the Court of Appeal pointed out,
I'm sorry, could you just give me the judge's holding, the paragraph reference for the judge on all this?
Well, the judge, perhaps Mr. Maycroft can give me that, the judge is acquittals of the other witnesses.
So you particularly said, he said in relation to Mr. Shaw that he did not understand references to non-aggregation as...
No, he doesn't specifically deal with it in relation to Mr. Shaw. I think it's 166. Right. Let me just check that reference, if I may. 166, there may be other references I can give your ladyship, but 166 is dealing with the credit personnel in Jersey. If your ladyship sees the heading, Mr. McLean, Mr. McLean, I think it was Mr. Hewitt and Mr. Simpson, they're all credit personnel in Jersey. And he says roughly halfway down, paragraph 166, this isn't the only point he's dealing with, but he says halfway down, the credit applications and excess referrals make it clear that issues of segregation were being dealt with. It's entirely reasonable for the credit managers to rely on those assurances from the relationship manager. And 162, sorry, Matt.
It's about understanding the meaning. You're saying the judge did not consider that any of the witnesses understood references to non-segregation as theft. I've got J166, and then it's 162, do you say?
162, I think, Mr. Medcroft, was the Mr. Ramaggi was the assistant to Mr. Shaw and then became a relationship manager. Your Ladyship will have to bear with me a little because one will need to see this point being built up from the judgment and in the Court of Appeal, but Your Ladyship's entirely right to start with the judgment. So although they don't say in terms what I have said, one has to remember the case being put to all these witnesses in credit and to the other witnesses in Gibraltar was that every time you see non-segregation, it's synonymous ipso facto with fraud. And this judge makes his findings in 162 and 166, and then those are picked up in the three references I gave in the Court of Appeal. So that's the paragraph 72, 75 and 196 in the Court of Appeal, which is where the Court of Appeal then look at those findings that I've just identified in the judgment. So perhaps we can go to 72 of the Court of Appeal. One wanted to sort of mentally or actually scribble, as it were, in the margin. This is commenting on 162 of the judge. 72 in the Court of Appeal. The Court of Appeal make the point that line 5, whatever understanding of the references to segregation or non-segregation, i.e. it is all a bit unclear, but what he can't have meant and what it can't be is that Mr. Shaw had discovered that the firm was stealing monies. He could hardly have regarded the references as difficulties that Mr. Ramaj had thought had been sorted out were or had been references to theft. And then in 75 he makes the same point in relation to the credit witnesses as he's just made in relation to Mr. Ramaj. Those individuals in credit can't have regarded the issues of segregation as reflecting a discovery that the firm was stealing from the clients. So the ipso facto case, the synonymous case, which was put, the judge did not accept. And as the Court of Appeal rightly point out, he cannot have thought that all those witnesses who were acquitted of any knowledge of dishonesty or any blind eye behaviour could have understood that the references to non-segregation, whatever they quite meant, or meant in 12 years earlier, were synonymous with theft.
But
now, in relation...
Yeah.
Sorry, Matt.
No, I was going to say he wasn't dealing with Mr. Shaw.
No, and that was my next point, and it's entirely right to note that although he found Mr. Shaw an unsatisfactory witness in some respects, and indeed finds him dishonest for other reasons, as we know, and indeed he takes the odd swipe at Mr. Shaw in relation to non-segregation. The word swipe comes from Sir Colin Rymer's judgment, where the Court of Appeal acknowledged the judge took a swipe or two against Mr. Shaw in relation to this part of the case. The judge did not make a finding. He did not rely upon this aspect of the case, the non-segregation strand, if you like, as being a basis for finding Mr. Shaw dishonest.
But I'm so sorry, I didn't mean to cut you off.
No, and you didn't, my lady, and your question is presumably, if I may disrespectfully anticipate the question, that's not quite the same as saying that he acquitted Mr. Shaw in terms. He doesn't.
No, I wasn't going to say that. I was going to say, because he didn't make a finding, that it is said there is an outstanding issue.
No, well, that doesn't follow. He doesn't specifically, in relation to Mr. Shaw, find him dishonest for that reason, but he has already found all the other witnesses who had the same information and received the same documents and contributed to the debate as not understanding that these were references synonymously to theft or misappropriation. And at the end of the day, I think it's perhaps became clear from my exchange with Lord Reid shortly after the short adjournment, at the end of the day, the evidence was what it was. The judge made of it what he made of it. He made findings of dishonesty as he saw fit. There is no material, once those findings have been discarded, there was no material to support a finding of dishonesty, let alone a good reason for saying the whole matter should be retried. It's not quite the same question, because even if this court felt, well, there was this loose end here and that loose end there, it doesn't follow because this isn't a strikeout. It doesn't follow that one should have a retrial of every loose end in the case, particularly in circumstances where the Court of Appeal has said, and it's not appealed, that there is no foundation to these allegations, including these allegations of non-segregation. And, of course, this is where the cross-appeal comes in. This board has the confidence of knowing that this Court of Appeal independently considered the question, because it was asked to do so by reason of the cross-appeal, as to whether or not non-segregation was a proper basis or would have been a proper basis in the alternative for a finding of dishonesty. And for reasons which they explain in a different part of the judgment, it's the end of the judgment from 195 onwards, that's that last section, that's where they deal with that under the heading of the cross-appeal. They look at this as a matter of substance and of merit, and they are not persuaded from the materials which they're reviewing and evaluating that there is any basis for saying Mr. Shaw had discovered theft or was referring to theft when he was talking about non-segregation difficulties. I'm about to expose my ignorance of the settled practice of concurrent findings in the Privy Council by suggesting that the judge has looked at the material and has not found dishonesty on this basis, and the Court of Appeal has looked at the material and has not found dishonesty on that basis. And that is, I believe, technically, but if not technically in substance, a situation where two courts have looked at the material and come to the same view on the evidence, and the Privy Council does not ordinarily look at it again, unless there's some serious problem with it. So it's up to the claimants, the appellants now, to show that there was an error of principle in relation to both the way the judge dealt with this and the Court of Appeal reviewed it. So there's no loose end here. Alternatively, no loose end that justifies a retrial. The pleaded case, and this was pleaded, was put. It was explored at length. The answers were given. The Court of Appeal weren't saying the answers were given and we accept the answers. Their comment in 213 is to the effect that it was all put, the answers were given, we've looked at all the material, we've looked at the answers, we've looked at the inherent probabilities, and there's nothing to it. It's without foundation or unsustainable, to use the language of the substantive judgment. And the Court of Appeal were plainly entitled, we say, to take that view in their discretion. They didn't overlook any evidence or ignore it. They looked at it very carefully. Now, the final part of my submissions about non-segregation do go slightly into the weeds even further, but it's this submission that I've explained why the case was simple. Non-segregation is synonymous with theft. It was also, with the greatest respect, simplistic, and was put in a very simplistic way, because the evidence about non-segregation was nuanced, confused, complicated. It was a very, very long time ago, 12 years ago at the time of the trial. Mr. Shaw couldn't remember the origin of it. It almost certainly was an inherited problem for Mrs. Lester, who couldn't remember anything about it. Just by way of examples of why it was nuanced and complicated, and it's not going to get any easier on our retrial 15 years later, which is when it would be tried. The judge had already found that the custom was chaotic, was mixing monies. Mrs. Lester gave evidence that they were putting their own money into the client accounts, and they weren't paying themselves fees promptly. All the witnesses had understood wrongly that this was not a legal requirement in Gibraltar, i.e. that that was a rule of accounting that was not yet in force.
But it was a rule of good practice, which it was understood leading law firms adopted.
It's a rule of good practice on the law firm, not on the bank. The bank doesn't have to segregate anything, but it was, I think, a regulatory requirement. It's not a criminal offence, by the way. It was a regulatory requirement, and as a matter of common sense, one might think solicitors ought to segregate funds. But the bank's understanding was that this was not a requirement at the time. So they can't have understood, when they referred to non-segregation, that the customer was stealing money. They can't have thought, lucky, it's not illegal at the moment to steal money in Gibraltar, but goodness sake, the law's going to change in 2006. And, I mean, that is the essence of the simplicity and the simplistic, if I may say so, with respect to nature of the case that was run. And so one gets from the transcript a state of uncertainty, and the Court of Appeal, and this is important, the Court of Appeal say that some of Mr. Shaw's answers are not impressive. Well, I rely upon that for showing that the Court of Appeal did not make the error when they came to the retrial of thinking Mr. Shaw was a fantastic witness in all respects. They acknowledged that some of these answers were unclear. They criticised my learned friend's lack of a glossary in the cross-examination, a clarity of precisely what the terminology was talking about. They criticised Mr. Shaw, in effect, for not being as impressive as he could be. But standing back, they didn't rely upon him being a great witness or a fantastic person. Standing back, they didn't make their decision on a retrial on the basis of credibility of Mr. Shaw. They made it on a different basis. And at the heart of my learned friend's appeal, the big point, as I understand it from his written case, if one distills it out, is that there was this big issue about the credibility of Mr. Shaw, and that's why there should have been a retrial. That's not the basis of the Court of Appeal's decision. They didn't make that error or need to form a view on that primary finding of fact, which of course would be a matter for the judge who saw the witnesses. My lords and my lady, we deal with other points in the case, which I won't develop. We deal with this quite shortly in our case. I think it's paragraph 66 and 67. I would just invite the court to read that. We've tried to distill the essential points into really 2 pages. And if you want a longer version of it, then there isn't any substitute in our submission to reading the Court of Appeal's judgment, which is in that last section of the judgment, which goes through it in more detail. But we have distilled out some of the more granular points and given some other references. My Lord Mayor, sorry, I'm just pausing because I think Lady Arden asked a question about some references, and we're seeing whether or not I can.
Thank you.
Whether to give them. Yes, thank you very much. This may go back a few too many questions ago, but you did ask a question about where would you find a clear reference or a clearer reference to for the proposition that the case at trial in relation to the individuals was, in a sense, they were all in it together, all the relationship managers and all the people in credit. And paragraph 20 of the Court of Appeal is a reference to that.
Thank you.
Oh, and it's grateful. And it's also, as it happens, the answer to another of your Ladyship's questions, which was, where do we find the Court of Appeal, as it were, drawing all the strands together and deciding, as a matter of generality, without false distinctions between topics, whether or not there was any material which justified the inference of dishonesty. And as one might expect, it's paragraph
Which paragraph were you looking at?
20 of the cost judgment.
20 of the costs, thank you.
Cost judgment, we say, is helpful because, in answer to my lady's point, really, it's that occasion, isn't it, at a trial when, or at a hearing, when the court does stand back and review the whole totality of the submissions to see whether or not, in that case, the issue is being whether the conduct was exceptional and out of the norm. But they're standing back and reviewing the material, and it's in that context, between 18 and 21, where they say, amongst other things, without foundation.
Just going to observe that the Court of Appeal at least used to take the view that once you'd exercised a discretion and given reasons, that was it. You couldn't add to them.
Well, what a very good principle that would be.
But you would no doubt say this is just clarification.
Yeah. They had very lengthy submissions on costs. I think they felt the need to be conscientious.
Yes, of course.
And deal with them.
The point I was making earlier wasn't that this was adding to the reasons, but that insofar as we were construing what the Court of Appeal was saying in the substantive judgment,
yes,
certain parts, one might get a flavour from the paragraphs to which you refer.
Yes, and my lord, I think I agreed with that.
Yes.
And if you wanted a paragraph within the substantive judgment that's perhaps closest to that, it would be 209 of the Court of Appeal. The section at the end. Which, if I can put it in the vernacular, is, once you strip the judge's errors out, there just ain't nothing left to build a judgment or finding a dishonesty. My lady, my lords, I was going to say no more about my last topic, and I was going to conclude with a few remarks, if I may, and then I'll finish early, subject to any questions. We do ask the court to stand back and be realistic. Any retrial of this case would take place, I think it would be 15 years after the relevant events if it was tried next year. 15 years. The bank officials had 12 years, as it were, passage of time at the trial, and had very little recollection of any of the events other than as prompted by the documents. They dealt with hundreds of customers, hundreds of matters over their careers. And if one focuses on Mr. Shaw, he had, as he always said in his witness statement and in his evidence, very little recollection unassisted by his documents. And so one can make these sort of additional remarks that his recollection is not going to improve with a retrial. He left the bank, I think, 10 years ago. He's now retired. He's not going to make admissions of dishonesty at a retrial. So the fact of the matter is that even if one had a retrial, it's going to turn on what those documents fairly could have meant and were fairly understood at the time, which is precisely the task that the Court of Appeal embarked upon and looked at in great detail. And the reason for that is that courts don't or shouldn't make findings of dishonesty on the basis of demeanour alone. It's extremely dangerous, and it would be quite wrong to do so. You make judgments, particularly about events a long time ago, by reference to as many objective benchmarks that you can identify in the materials. And that was a point which, as I said earlier, Lord Justice Robert Gough made a long time ago, and Mr. Justice Leggett, as he then was, picked up, in particularly in commercial cases which depend upon not real things that happen to people in lives, but their professional lives, where they have lots and lots of things to remember and do. And we do highlight, finally, the point we make in our written case at paragraph 53. And I'm conscious that, if I can just turn that up, our written case, paragraph 53. I'm conscious that raising it in this way may telegraph that this is very much a tail-end Charlie point, and it is my last point, but it is actually of some importance. We do complain that the appellants didn't raise the retrial issue properly, or actually at all, in their appellate pleadings, because we have been prejudiced, and we would have put in evidence before the Court of Appeal as to why we would suffer prejudice if a retrial would take place. Now, if this was the only point in the case, I would hardly make it, but it is additional and important and reflects the human dimension of real litigation involving real witnesses and real people coming back. And there are two individuals only who are still employed by the bank. Dare say technically we could require Mrs. Lester to come here if she's still employed by us, but she doesn't want to come, I say here, to a retrial, and she was very ill on the previous occasion. So we, the bank, would be prejudiced by a retrial, even if the allegations were restricted, as it were, to Mr. Shaw, because we would still want to call his predecessor, his successor, his assistant, Mr. Ramaj, who was both his assistant and successor, and the credit people, to say that, well, Mr. Shaw never told us, and we don't believe he ever spotted anything. Perhaps he should have done, but he didn't. Lady, my lords, subject to any questions, those were my submissions.
I don't think we have any questions for you, Mr. Mitchell. Thank you very much. Mr. Medcroft, do you follow? Yes, Mr. Mobley-Smith.
If I can just deal first of all with that last point. In relation to whether or not the bank was prejudiced, the bank had the opportunity before Justice of Appeal Reimer to raise any points it wished to in relation to that aspect. If there was a concern that they hadn't had enough opportunity to adduce evidence in relation to any aspect, they could obviously have asked for an adjournment. We even raised the point. Neither of those things happened. They made their submissions, we made our submissions, and the learned judge then determined the issue in relation to retrial. So the matter was before the court. And in terms of prejudice, the position here is no different from the position in the Giska case. That again was a case involving dishonest assistance, again a case involving matters that took place 15 years ago. And in that situation, the Court of Appeal had no trouble in saying there should be a retrial. So looking at the two cases together, there's no reason why, if you order a retrial in one, you should, for the same reason, not order a retrial in the other. And as I say, there's no evidence before the court about this matter. My learned friend could have put some evidence before the board in order to elaborate on this point. He hasn't done so, and therefore it's not really a point that can be taken in any proper way before the court at the moment. In relation to the approach of the Court of Appeal, the Court of Appeal was, of course, dealing with the way the judge had put the case and decided the case. And what the judge had done was to go down the path of looking at the investigation of Mr. Shaw rather than looking at our primary case. And so the fact that the Court of Appeal was focusing on what the judge did and answering what the judge's points were in relation, for instance, to motive, doesn't really answer the fact that our primary case was not being considered by the Court of Appeal. It only considered
Could you just define your primary case again for us?
The primary case is that the documents that you saw this morning, on their face, as my learned friend said, on their face, identifies non-segregation. Mr. Shaw, in his evidence, acknowledged that non-segregation was something that was reportable, that was a breach of the bank's policy and a breach of the SFC requirements. Those things he knew, both at the trial and at the time. So therefore, on the basis of his own words, used both in oral evidence and in the documents, he was admitting that the bank was seeing non-segregation, was seeing a misuse of money that should be reported.
Misuse of money?
That should have been reported.
This should have been reported.
And it was improper, and after 2006 was unlawful on his analysis of the law.
I thought we were looking at answers this morning, which he said, nothing suggested misuse of monies to me.
Yes, he said that, and that's exactly my point, my lord. He said that, whilst at the same time producing a document that said the opposite, and whilst at the same time apparently understanding that that opposite was something that required him to have reported the matter with a suspicious transaction report. So that's precisely the problem. You have him on the one hand saying there was nothing to report, I saw nothing wrong. On the other hand, in the written documents, saying exactly the opposite.
What would be very helpful is to have a photocopy of that page in your amended particulars with the documents you're relying on, with the references in the bundle.
Certainly produce that.
Thank you very much.
I think I might be able to help the ladyship.
Oh, thank you.
I was making these notes this morning as you went through them.
Yes, I'm sorry I had to dart around in the evidence because the judge, neither the judge nor the Court of Appeal had addressed these points that were in the evidence, and that was one of the problems I was having this morning. We can certainly do that.
Thank you.
I think you also, or somebody raised the question as to where in the pleading we had raised the point about the documents, and we can certainly make reference to that. That's paragraphs 21 and 22 of our amended particulars, which is for your reference, paragraph E, page E247.
Could I just ask a follow-on from my Lord Wilson's point? Can we say that the question which the summary you've just given us, the formulation of your primary case, is also the issue which you wish to be remitted for retrial?
It is exactly that, yes.
I mean, it may be helpful to have it in writing too.
Yes, of course, we can certainly do. And I think that would address the point my learned friend makes, which is that the Court of Appeal in paragraph 212 gave us one of their reasons for not giving a retrial, that we were going to bring back in the allegations against the others. Well, if we were able to confine our case simply to Mr. Shaw, then that point is obviously answered. I mean, the point to remember at the end of the day is it's a case against the bank, not against the individuals. It's not as if there's a series of individuals we brought a case against, and essentially we would be proceeding against one individual rather than another individual. We're proceeding against the bank, and the only question is what evidence is there? Where does it come from to show that the bank had knowledge?
But quite a few of these individuals saw these documents saying occasional non-segregation.
Exactly.
If that means occasional theft, then they were apprised of it.
Well, I think in relation to the individuals that were, whose evidence was explored, you had Mr. McLean, and he understood from, because Mr. Shaw had said to him, the local legislation doesn't prevent it, but will prevent it next year. As you saw in his report, he reported back saying, well, it's got to be sorted out by next year. It's currently not unlawful, he says, it's got to be sorted out. So he wasn't understanding it to be unlawful, but that's because of what he was told by Mr. Shaw. In relation to Mr. Heward did understand it to be unlawful. He did understand there to be doubts as to whether or not they were still doing it. He saw that as being a sensitive issue. Credit accounts are a sensitive, client accounts are a sensitive issue. He saw it as something that might cause reputational damage to the bank, but was countenancing the fact that it might continue. If it were to continue, the manager should be appraised of what was going on. So that was Mr. Heward. Those are the two whose evidence was explored in any detail. Mr. Ramage, who comes after Mr. Shaw, what the judge says about him is he was entitled to believe that it had been sorted out by Mr. Shaw, i.e. he was entitled to believe that there was no longer unlawful or improper conduct going on. So in relation to the relevant three individuals, both the learned judge did address their position, and he took the view in relation to Mr. Heward that Mr. Heward should be excused. What the Court of Appeal sought to say was because they were seeing non-segregation, they were immediately to be assuming on the judge's version of events that theft was taking place and were countenancing theft. Well, that of course all depends on what they understood by non-segregation and whether they thought it was improper borrowing as something that ought not to be countenanced but something they're prepared to tolerate, or whether they thought it was grand-scale plundering, which is how the Court of Appeal viewed it. And what my learned friend, of course, focuses on every time the point's raised is theft, theft, theft. They were seeing theft. How could they possibly have seen theft? But that overlooks the fact that if you don't view it as theft, if you don't view it as something that wrong, then you are prepared to tolerate it. And you can see that Mr. Shaw says in his evidence, he says he didn't view it as a serious issue in relation to the 2006 application. We could perhaps turn to that reference in a moment. We get my learned friend just to bring up that reference. But it all depends on how people view non-segregation. As lawyers, obviously...
It all depends, doesn't it, on whether the recipient of a statement that there had been non-segregation, who turns it round into a positive and assumes it means mixing of client and office monies in one account, knows that there is only one account in which that could have occurred, and that account was overdrawn.
Precisely. They may have known about...
Who do you say knew that, apart from Mr. Shaw?
Mr. Shaw knew that. And Mr. Shaw is the one who says, I know all about client accounts. I know you shouldn't, but you should segregate. That's Mr. Shaw's evidence. In relation to the others, they're remote, they're in the credit department. It's not their bag. No. And all they're doing is responding to what Mr. Shaw's told them. Now, we took a view in our pleaded case that they had knowledge of what was going on. But maybe that was a big over-ambitious in terms of what we thought we would be able to prove. But at the end of the day, it was Mr. Shaw who was the gentleman who said, yes, I understand all about client accounts, I understand all about non-segregation. And he's the one who repeatedly says, if there's non-segregation, I must report it.
I'm just wondering, on your approach, is a retrial actually necessary, or could we not, on your approach, infer knowledge of dishonesty from the documents themselves?
Well, you could say if you have the problem that Mr. Shaw, all the way through, has said, I never saw anything. And so you would have to disbelieve Mr. Shaw and resolve that conflict against him by saying, I make a finding of dishonesty. And normally an appellate court's not really in a position to do that, because it does depend how well he comes across in saying, that's my explanation.
So you're not saying that the remarks he made in writing about non-segregation, taken together with the spreadsheet, are enough in themselves to lead to a reasonable inference of knowledge of dishonesty?
Well, we said to the Court of Appeal that they did, in the sense that they were additional reasons that the Court of Appeal could rely on.
Yeah.
But I think we recognise that, I think there is a case, there was a case in 2015 when I think the board did decide, it's in the bundle somewhere, did decide that somebody was dishonest.
The Ecuador case.
Yes, exactly, yes. Thank you for reminding me. You did decide somebody was dishonest, notwithstanding it wasn't the finding at first instance. But obviously it's highly exceptional. And I think you would have to be absolutely certain as to the position. What we are saying is the overall probability is that Mr. Shaw was seeing something. That's something, and don't forget it's something that he says improved. So it's obviously a situation he's talking about that's improved. But one thing you haven't heard from the bank today is anything about what they understood or Mr. Shaw understood non-segregation to mean. There's no alternative that's been put forward.
Could I just clarify one thing? There are references to the Marash's accounting systems being chaotic.
Yes.
And non-segregation can work two ways, obviously. The office money can end up in client accounts and vice versa. Was it clear from the context that it was always a matter of non-segregation was client money ending up in the office account and not vice versa.
There was no suggestion from Mr. Shaw that it was vice versa.
No.
I think there was some evidence from Mrs. Lester, but Mrs. Lester, I think, was looking at it from the point of view that if they hadn't billed, then so there was a liability owed from a client to the firm, and they hadn't billed properly so as to be able to transfer, then she was, I think, viewing that as being money that belonged to the firm. But that wasn't Mr. Shaw's view.
No. But I mean, was there any contextual evidence as to the state of the Morash accounts?
In terms of what the balances were, what was due to whom, obviously there were bank statements.
No, but now, because we've been focusing on non-segregation simply as money transferred from the client account to
Yes.
the office account.
And that's the only way we see money being transferred in relation to the banks.
Yes, but there was no evidence led by the bank that office money had gone into the client account or anything like that?
No.
No, okay.
My other question is, how sound is the notion that Mr. Shaw must have known there was only one office account if the firm had more than one bank?
He knew that. So in terms of this bank, he carried out an account inquiry. So he got a list. Part of the evidence was he had a list of all the accounts.
I quite understand he knew
so he knew about that.
Account in this bank.
Yes.
But his original admission that there had been some non-segregation is highly unspecific as to where or in what account or how or with what bank.
Yes. But in terms, bearing in mind his role, it's unlikely he would have been talking about something that was happening in another bank. There's no suggestion in his evidence he thought he was doing that. And of course, he's talking about the situation having improved in 2006, which must be in relation to his own management. He's hardly likely to be talking about what might have happened in another bank. Your Lordship's right. In theory, there's a very, very outside possibility he might have been, but it wasn't his evidence. There's no suggestion of it, and it was never the bank's case that he might have been.
Well, can I just raise a point by way of factual correction? May I do that? I don't want to.
Of course.
Yes,
Lord
it's on the question of transfers into the client account.
Yes, it was Lord Hodge's question about that. You might want to look at paragraph 44 of the judgment and paragraph 30 of the Court of Appeal.
So 44.
44 of the judgment is referring to Mrs. Lester's evidence that monies belonging to the firm were paid into the client account and then not promptly or efficiently transferred, and that's picked up in paragraph 30 of the Court of Appeal judgment. So there was evidence led by the bank.
I think that was the point I was.
Yeah, but it's not a point of liability. It wasn't a question of the firm having the benefit of a claim for fees. These were actually monies paid. It's very clear from paragraph 30 of the Court of Appeal, line 4. Monies had been paid by the clients for fees to the client accounts. One ordinarily would expect that to go to the office account. And Mrs. Lester's evidence, which is accepted, was that has been going on for quite a long time, well before Mr. Shaw came on board. that is firm money in the client account. Chancery lawyer would make of that, but in terms of a banker, it's in the wrong place. And the problem about the overdraft, which is the relevance here, the firm's running an overdraft partly because of tax advice to run it an overdraft, but the problem with the overdraft is they're not drawing their own money into their own office account when either at all or efficiently.
Yes, I see.
I don't quite read those paragraphs in that way.
One final reference I should give, which is paragraph 198.
Of the
198 of the Court of Appeal. where the problem in this case is that I think your Lord will ask question about whether there's a reconciliation or a state of affairs of what was going on in various Marachi accounts at the time, and there simply wasn't any evidence. As the Court of Appeal rightly recalled, there was no evidence of instances in which the firm did so mix office money. They could have done, but there's no material against which to check the contemporary.
But that's precisely my point. That there wasn't any evidence that there was any mixing of office and client money in a single account. What there was client money being paid into an overdrawn account, which obviously then doesn't result in any
But you can clearly found on what's said at the opening words of 198. Yeah. Yes.
Yes. And if you look back to paragraph 44 in relation to Mrs. Lester,
Yes.
what she, I think, is saying is if you look at this third sentence of paragraph 44, which was the point I was seeking to make, is that they had billed clients but failed to transfer the money from the client account to the office account. So there was then a liability that would have justified a payment from the client account to the office account, but they never got round to transferring it. Now, that, of course, has nothing to do with non-segregation. It's simply a question of not organising your affairs sufficiently so you've got enough cash flow. And that's what Mrs. Lester was concerned with. But there's no suggestion that the clients were paying the money into the wrong account and somehow, office money was somehow being paid by the firm into the client account, which is what would have to happen for the client account to have anything in it other than client money.
Yes, I think we've got that clarified now.
Yeah, I'm grateful. Thank you very much. So we do say the only situation where you have anything that can be described as non-segregation is client money going into the office account and it being overdrawn. I've made that point several times, so I probably don't need to do it again. In terms of the point my lady made about should we have raised this with the learned judge, obviously, with hindsight, perhaps the ladyship's correct, we should have said something more. But of course, at that point, we had a finding in our favour that there was dishonesty. These are additional reasons for finding that Mr. Shaw had been dishonest. The case was made out that there was dishonest assistance by the bank. And perhaps in an ideal world, we could have said, by the way, could you now give us these extra half dozen reasons to justify the judgment you've already given? But in the real world, I think that's a counsel of perfection. I'm not sure many successful claimants turn around to the judge and say, thank you very much for the judgment, but could you now elaborate further?
Well, even though when you got the draft, you said to yourselves, these findings in our favour are unsustainable.
Well, in terms of the finding in relation to the Bautista conversation, I accept that we perhaps should have done more about that. The bank, of course, didn't do anything about that either. They didn't try and correct the judge. I mean, I think both of us perhaps should have gone back to the judge and said, actually, you've got the facts wrong there. And possibly also in relation to the note. And as I say, with hindsight, no doubt both of us should have done that. I think we're probably both to blame because those matters could have been resolved and the matter not have had to go to the Court of Appeal in relation to those aspects. But in relation to other findings, for instance, the demeanour of Mr. Shaw, Mr. Shaw's answers to the other aspects of the case, and the inconsistency in relation to his suggestion that he was carrying out an analysis of turnover against monies going into the client account, and the fact that that exercise could only be carried out by looking at all the client accounts, which he was busy denying he'd ever done. All were matters that plainly would support the judgment, the aspects where Mr. Shaw has given evidence that the judge could rightly say was incredible. So, as I say, with hindsight, perhaps things could have been slightly better. But I mean, perhaps in cases of trials, it's often the case. You maybe don't always focus on the right point.
Yes.
But that shouldn't mean that at this stage we shouldn't have a retrial of an issue that hasn't been addressed by the court, and it wasn't addressed by the Court of Appeal either, other than in the context.
Now you've said that your central point on retrial is non-segregation.
Yes.
I've been looking at all the paragraphs in the Court of Appeal under the heading cross-appeal, and correct me if I'm wrong, Mr. Mobley-Smith, they are all about non-segregation.
That's right, yes. In relation to, well, because that was the point on the cross-appeal.
Yes,
exactly, yes.
This point has been intensively examined at your request in Gibraltar.
The point has been examined in the Court of Appeal, obviously, because, as you say, it was our cross-appeal. But it was examined in the context of whether or not what we were saying was something that could support the judgment, notwithstanding the other findings have been knocked away. And in that context, we have the problem that the Court of Appeal is not in a position to make a finding of dishonesty against Mr. Shaw if there's not otherwise a finding of dishonesty against Mr. Shaw. And so, yes, you're quite right that the Justice of Appeal Reimer goes through the point and says, I can't decide what non-segregation means. Mr. Shaw's evidence was unsatisfactory in relation to this. He says all those points. And so he's accepting that Mr. Shaw hadn't given any clear evidence about what he meant. And that, of course, throws you back on the question of credibility. What is the proper way of analysing what he's said, both in relation to what he says in writing in the applications and what he says orally in his cross-examination, the two being entirely inconsistent. Now, as far as Justice of Appeal Reimer is concerned, as I say, what he was struggling with was how he could make that finding. He says, I think, in paragraph 209, that the points we've raised do not enable him to build an alternative basis for maintaining a judgment. So that was the exercise he was carrying out. And in relation to what he thought he was able to do, you see him analysing the position in 205 and concluding in 206 that the Court of Appeal is not in a position to carry out the exercise I was inviting him to do, which was to determine the matter on the documents. So I hope that's an answer to my Lord's problem. There does remain outstanding, despite all that is said by Justice of Appeal Reimer, an issue that hasn't been resolved. It was said that the decision in the Court of Appeal not to challenge the acquittals, as it was put, of the others was a tactical decision by the claimant, so that they could support, the claimants could support the judge's analysis of burying the findings and hoping everything would go away. We were not actually actively seeking to uphold that aspect of the judgment. Our case was that Mr. Shaw had reported the non-segregation. That was seen by all the individuals we identified. So we weren't saying in any shape or form there was a burying of material, and plainly we couldn't say it because obviously the documents had been shown to the individuals. So it was never our case, it was the judge's case. We didn't invite him to say that. It was his if I can, without being too disparaging, it's his frolic, in the sense that he had decided that this is what Mr. Shaw was about, and had decided to bolt in the Bautista conversation evidence as part of his overall scheme to try and hide the fact that he had discovered misappropriation of money. But none of that was ever our case. So we didn't take any tactical view in the Court of Appeal. The reason we didn't attack in the Court of Appeal the acquittal was because we recognised the Court of Appeal was never going to be in a position to say these individuals who are dealt with in the judgment Mr. Cartwright in one sentence and Mr. Hewitt, I think, in 2 paragraphs. The Court of Appeal is never going to be in a position to say we make a finding of dishonesty against those individuals. And so it was impossible for us to have taken that point, and therefore we didn't take it. We weren't making some sort of tactical, decision otherwise in relation to how we approached the appeal. In relation to the Giska case, and you taxed me, my Lord Wilson, taxed me for going into it in some detail, but I went into it in some detail to show you that very much the same sort of failings on the part of the judge in that case arose in this case. And my learned friend picks up the point of expert evidence and says, well, here was a judge who ignored all the expert evidence. In our case, in relation to bunching, for instance, that was never part of our case. That was another frolic of the judge. And in relation to that aspect, the Court of Appeal said, well, you needed expert evidence to that. So it was a case, in one case he was ignoring expert evidence, in the other case he was making findings without expert evidence, but it's essentially the same sort of issue. And in relation to other findings of fact, the whole series of other findings of fact as well, again, similarities to what we have in our case. We have a finding of perjury, which is very similar to the finding made in relation to the Bautista conversation. All the same sort of findings. Yet all that leads to, in that case, is a retrial. So why doesn't it in this case? And there's no clear distinction or explanation as to why. In terms of principles, which I think was the other point that my friend made, was no error of principle by the Court of Appeal. The Court of Appeal did identify as a relevant factor whether or not the case was destined to fail in the Giska case. That was a factor not addressed at all in our case.
They used different language, but they said they thought the case was unsustainable.
Yeah. No, I think if we look back to it, what they said was that the judge's findings of dishonesty were unsustainable.
Oh, right.
My learned friend, I think, slightly misled you in relation to paragraph 213.
Yes.
No, but at 209, they are surely saying that there is no alternative way to put the case that is sustainable.
In order to maintain the judgment.
Well, i.e.,
Yeah.
the successful outcome for your clients, not to maintain the detailed reasoning of the judge.
No. My Lord's absolutely right. But obviously, at this stage, he was seeing whether there was the ability to maintain the judgment. And one of the reasons
their judgment surely means the order in their favour.
Yes, the order in our favour, exactly. But the reason he can't do it is what he says in paragraph 206, which is because he can't make a finding of dishonesty in the Court of Appeal. He says the judge's findings are flawed from beginning to end, so there's no other dishonesty finding I can latch this onto. We therefore would have to make a finding of dishonesty in the Court of Appeal. We're not able to do so. Because nowhere do you find the judge in these paragraphs saying, analysing the point I'm making about non-segregation, what Mr. Shaw must have meant by non-segregation. He simply says, I can't decide that. I don't know the answer to that question.
That construction is difficult to support when you turn to the costs judgment and see that what's being asserted is that the whole thing was speculative and unfounded.
I think if you turn to the cost judgment, essentially what was being said was that we had approached the matter on the basis that we were going to rely on the bank's discovery and what we got out of cross-examination to make our case. Well, I think it's in that context that the learned judge is saying that it was speculative. But one doesn't find in that judgment any explanation as to why the points I've made this morning are unsustainable. It's not addressed by reference to the documents as to why what we're saying is wrong. I think that what the judge was saying is that if you make allegations of dishonesty and you're relying on what the bank happens to give you, that's speculative litigation at its worst, is the view he was taking. And for that, we should be penalised in indemnity costs. But as I say, at the end of the day, I think there's no clear finding that our case is unsustainable. And as I hope I've explained, there's a proper basis for our claim, namely that it's an admission of non-segregation. I think even the bank admitted that on the face of the documents, that's what Mr. Shaw was saying. And so therefore, if that is what Mr. Shaw is saying, the only question is, what did he mean by what he said? And no one's put forward an alternative to the alternative to what we've said. I don't know if any other points I need to address. Can I just take... I just want to check a little further. Mr. Simpson was just reminding me that, for the purposes of your note, in relation to how Mr. Shaw understood segregation and non-segregation, paragraphs 96 and 101 of his witness statements. His first witness statement should be...
Reference?
Paragraphs 96...
I know, page?
Page E914 and E915.
Thank you.
And I think, sorry, I have noticed a couple of other points I need to address. A point was made that there had already been concurrent findings in relation to our claim in the Court of First Instance and in the Court of Appeal, and we're now seeking essentially a third bite of the cherry. And our simple position there is there was no finding before the judge, and on analysis, no finding before the Court of Appeal just wasn't able to come to that conclusion. So therefore there are loose ends, the loose ends we've described. There wasn't confused evidence about non-segregation. There's essentially no evidence about non-segregation, what Mr. Shaw meant by that term. And my learned friend characterises our case as simplistic. On the contrary, what we say is the evidence from the bank is straightforward, and we're simply relying on what the bank has said, the factual background of the nature of the accounts and which accounts overdrawn. We simply say, on the face of that material, there's an acknowledgement of misappropriation of funds. So simple it may be, simplistic it is not. I think unless there's anything further I can assist you.
Thank you very much indeed, Mr. Moverley-Smith. Well, we're most grateful to all counsel for their submissions. We will now take time to consider what advice we shall humbly tender to Her Majesty.